Okay, so imagine this. You've put down like a huge chunk of change for your dream apartment back in 2016, right? But then crickets. No construction, no updates, just years of like radio silence. And that's what happened to this guy, Vikas Sharma, in Gurugram, India. We're going deep into his legal battle with this real estate developer, Ramprastha Ser Gurugram. It's this case that's got more twists and turns than a mountain road. I mean, we're talking refund orders, bankruptcy proceedings, even whispers of forged documents.
Yeah, you know what's really fascinating about this case is how it kind of reveals the tension between these different legal realms. Like specifically, how do real estate laws that are designed to protect home buyers, how do those hold up against the complexities of, insolvency and bankruptcy procedures?
Yeah, that's a good point. So let's start with Vikas's story. He booked a flat in this development called Sports Park. This was back in 2016. Paid a significant amount and then nothing. Years passed and construction never even started.
Right, and so Vikas, he decided to take matters into his own hands, filed a complaint with the Haryana Real Estate Regulatory Authority, or HRER, which was specifically created to kind of safeguard home buyers' interests.
Okay, so HRR is like a watchdog then for buyers who get stuck in these kind of situations.
Exactly. Precisely. And so in 2021, HRA stepped in and they issued this refund order in Vikas's favor. They directed the developer to return his money. We're talking a whopping 18,080,000 rupees, plus interest and legal fees. I mean, you'd think that's where the story ends, right? Victory for the little guy.
Right. I mean, it should be that simple, but I'm guessing there's a catch.
Well, there's always a catch, right? So around the same time that HRA issued that refund order, the developer, Ramprastha Ser Gurugram, they hit some serious financial turbulence. They entered into what's called the Corporate Insolvency Resolution Process, or CRP.
Okay, now CRP, I'm sure a lot of our listeners might not be familiar with that. Can you break that down for us?
Sure. So imagine SERP is sort of a timeout for a company that's struggling to stay afloat, It's this process outlined in India's Insolvency and Bankruptcy Code of 2016. And it's designed to give these companies a chance to either restructure their debts, get back on solid ground, or, if that's not possible, to liquidate their assets in a controlled way.
So it's kind of like a last-ditch effort to either rescue the company or at least make sure its debts are settled as fairly as possible.
You got it, yeah. Now here's where things get particularly interesting. So when a company enters SERP, what happens is a moratorium is imposed.
A moratorium? Is that like a legal pause button or something?
Exactly. It basically means that creditors, those to whom the company owes money, they can't immediately go after what they're owed. It's like a temporary halt on all debt collection. It gives the struggling company some breathing room.
Gotcha. So how does this moratorium then affect Vikas and his refund order from HRA?
Well, that's the million-dollar question. So Vikas is arguing that his refund order, which remember was issued before the developer even entered Zurich, that it should stand regardless of this moratorium. It's a legal order from a statutory authority, right?
Right, yeah. He got that refund order fair and square before this whole bankruptcy issue even came up.
That's exactly his position. But the developer has a different perspective. They're essentially arguing that Vikas should have to, wait in line with all the other creditors and go through this whole CRP process.
Hold on, so we have a showdown brewing here. Real estate regulations versus bankruptcy proceedings. Whose claim reigns supreme?
It's a classic legal clash. Raises the question of which area of law takes precedence, right? And the developer is placing a lot of weight on something called the resolution plan. This is created as part of the CRP. Think of it as a roadmap for how the developer plans to, restructure their debts and potentially climb out of this financial hole. And this plan, it gets approved by the National Company Law Tribunal, or NCLT. They're the body that oversees these CRP proceedings.
So the developer's basically saying this NCLT-approved plan overrides everything, even Vikas's HRERA refund order.
That's their argument, yeah. And they're leaning hard on this legal concept known as the clean slate doctrine. Essentially suggests that once a company's resolution plan is approved, they get a fresh start. Old debts, with some exceptions, are wiped clean. It allows the company to move forward unburdened.
So it's like a financial do-over for the developer, but Vikas is saying, hold on, my case is different. I had a legal order in place before any of this happened.
Exactly. And he's not just relying on the timing. He's also pointing out that his refund, it relates specifically to the sports park project, which, get this, wasn't even included in the resolution plan. The plan was all about restructuring debts related to a different project called Crescent Park. It's like trying to apply a solution from one puzzle to a completely different puzzle.
Okay, so we've got Vikas arguing his claim is unique. It shouldn't be lumped in with the rest. And the developer saying, nope, Everyone plays by the rules of the resolution plan. But I have a feeling there's even more to this story. What about these allegations of forged documents I keep hearing about?
Oh, yes. The plot thickens.
Huh.
So to make things even more complicated, Vikas has filed a police report alleging that the developer tried to pull a fast one by using a forged settlement agreement.
A forged agreement? What were they even trying to achieve with that?
Hold on to your hats, because this is where the story takes a truly wild turn. Okay, so Vikas, he alleges that the developer basically forged his signature, right, on a settlement agreement to make it seem like he was actually seeking a refund for this Crescent Park project, the one that was actually covered by that resolution plan we talked about, instead of this sports park project that he really invested in.
So they were trying to make it look like he was part of that group, the one covered by the resolution plan, right? Talk about a sneaky maneuver. But why even go through all that trouble?
Well, remember, Vikas had that HRERA refund order, specifically for sports park. Right. So by making it look like he was part of the Crescent Park crowd, the developer could then argue that the clean slate from the resolution plan, that it wiped out his claim along with all the other Crescent Park debts.
Wow, that's some serious legal maneuvering. Makes you wonder what else they might be trying to hide. But let's kind of step back for a moment and really unpack Vikas's arguments here. What are like the legal pillars he's relying on to support his case?
So Vikas' legal team, they're bringing some strong points to the table. Firstly, they're hammering home the fact that the HRA refund order, it was issued well before the moratorium even came into play. So chronologically speaking, Vikas's right to a refund, it was established long before the insolvency proceedings and those limitations on debt recovery even began.
It seems pretty straightforward, right? He got the order before the developer even entered CRP, so how can they just ignore it?
Exactly, and to bolster this argument, Vikas's team is emphasizing that a moratorium, it doesn't automatically erase pre-existing rights. For a pre-existing right to be, like, nullified, it has to be specifically addressed in the resolution plan, which directly challenges the developer's whole clean slate defense.
So it's not enough for the developer to just cry bankruptcy and expect everything to vanish. They have to actually prove that the resolution plan either included a solution for Vikas or explicitly stated that his claim was no longer valid.
Precisely. They can't just conveniently sweep a legal obligation under the rug.
And we can't forget Vikas's third point. His case is tied to sports park, a project completely absent from the resolution plan. It's like they're trying to use a solution meant for one problem to fix something totally different.
You hit the nail on the head, yeah. And that's the challenge for Vikas, right? Proving that his right to a refund should override the general provisions of this resolution plan that doesn't even acknowledge his specific project.
So while Vikas has, like, a strong foundation for his arguments, I'm sure the developer isn't backing down without a fight. What are their counter-arguments then? Why do they think Vikas should have to take a number and wait his turn?
Well, the developer's main line of defense, it kind of hinges on this idea that the NCLT's approval of the resolution plan makes it the ultimate authority, you know? They argue that anything prior, including Vikas's HRERA order, it basically gets superseded by this NCLT-approved plan.
So it boils down to a power struggle, HRERA versus the NCLT. Who has the final say?
It's a classic legal dilemma, right? It highlights the friction between real estate regulations and the kind of overarching power of bankruptcy law. And the developer, they're still stubbornly clinging to that clean slate doctrine, claiming that it washes away all prior claims, including Vikas's refund.
But Vikas is basically saying, hold on, clean slate doesn't equal a free pass to ignore valid legal obligations, especially ones that predate this whole insolvency mess.
You summarized it perfectly. Vikas's team is arguing that clean slate can't be used as like this blanket excuse to disregard specific legally binding orders like his.
So we've got this legal tug-of-war over interpretations, but what about the elephant in the room, those forged documents? How does that factor into all of this?
The forgery allegation. It adds a whole new dimension of intrigue to this whole thing. I mean, if Vikas can prove this claim, it not only weakens the developer's position, but it could also lead to criminal charges against them.
It would certainly paint a pretty damning picture of their conduct. But even without the forgery issue, this case raises some pretty important questions. It's not just about Vikas anymore, right?
Absolutely. It goes beyond one homebuyer's struggle. It exposes the potential conflicts that can arise when insolvency proceedings kind of clash with other areas of law.
It really makes you think about the balance of power, then, between these regulatory bodies like HRERA, bankruptcy courts, and, of course, the rights of individuals like Vikas, who get caught in the crossfire.
It's a delicate balancing act. And this case really shines a light on the complexities involved.
So where do we go from here? What are the possible outcomes of this legal battle? And what could it mean for the future of real estate and bankruptcy law in India?
Well, that's exactly what we'll explore in the final part of our deep dive. We'll delve into the potential scenarios, the precedents this case might set, and what it all means for you, the listener.
All right, so welcome back, everyone. We've been navigating the twists and turns of Vikas Sharma's real estate saga. This case that's highlighted the clash between consumer rights, bankruptcy proceedings, and even allegations of forgery, right? It's a story that's kept us on the edge of our seats, and now we're reaching the climax. So what could the final act hold? What are the possible outcomes here?
Well, one scenario is that the court, sides with Vikas
Hmm.
and upholds that original HRERA refund order. This would be a pretty resounding victory, I think, forcing the developer to return his money despite being under bankruptcy protection.
Yeah, that would definitely send a powerful message to both home buyers and developers. It would reaffirm the strength of HRA in protecting consumers, show that even in bankruptcy cases, certain rights can't be simply dismissed.
Exactly. It would set a pretty compelling precedent, I think. Reinforcing that principle that pre-existing legal obligations,
Yeah.
they can't just vanish because the company runs into financial trouble.
Right, it's not a get out of jail free card, but let's flip the script for a moment. What if the court rules in favor of the developer? What happens to Vikas then?
Well, if the court sides with the developer, Vikas's claim would likely be treated like any other debt within the bankruptcy proceedings. He'd have wait his turn along with all the other creditors and hope to recover at least some portion of his money through that resolution plan. There's no guarantee he'd receive the full amount, or even a significant portion of it.
That would be a tough blow for Vikas, for sure. It raises concerns about the effectiveness of HRA in protecting buyers when developers go bankrupt. It's like the system is failing those who need its protection the most.
It definitely highlights the limitations of regulatory bodies. When they bump up against the complexities of these insolvency proceedings, and of course we can't forget about the wild card, those forgery allegations. If those are proven, it could drastically change the course of this case.
It would be a major turning point for sure. It's not just about a refund anymore. It's about potential criminal charges and a serious breach of trust. But even without the forgery issue, this case has exposed some broader issues that impact all of us, right?
Oh, absolutely. It's a stark reminder of the potential conflicts. Conflicts that can arise between these different areas of law, raises questions about how to strike a balance between protecting consumers, facilitating the resolution of corporate debt, and upholding the integrity of the legal system itself.
Yeah, it's a complex web. And navigating it requires awareness, diligence, and sometimes even a bit of legal savvy. So this deep dive has been a masterclass in the intricacies of the legal system, and it's a story that will continue to unfold.
Indeed, we'll be watching closely to see how this case is ultimately decided and what precedents it might set. The implications are pretty far-reaching, potentially shaping future real estate and bankruptcy cases in India.
Okay, so for our listeners then, what are the key takeaways here? What can we learn from Vikas Sharma's experience?
Well, I think this case serves as a cautionary tale, right? It highlights the importance of doing your due diligence before making major financial decisions. It underscores the need to understand the risks involved, particularly in sectors like real estate, which can be vulnerable to market fluctuations and developer challenges.
Yeah, it also reminds us that knowledge is power. Familiarize yourself with your rights. Research the regulations that protect consumers. And don't hesitate to seek expert legal advice when you're faced with, complex situations.
Exactly. And, if something seems too good to be true, it probably is. Don't let the allure of a great deal cloud your judgment. Always approach major financial commitments with a healthy dose of skepticism and thorough research.
This has been a deep dive full of unexpected turns, that's for sure. But the journey's not over. We'll keep you updated on any major developments in Vikas Sharma's case. And remember, when it comes to navigating the legal landscape, staying informed and vigilant is key. Thanks for joining us on this fascinating exploration IR on